This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why, if there is no breach of contract, there can never, ever be a case for bad faith, and a one-year suit provision in a policy will defeat a claim for any suit filed more than 1 year after the claim accrued. Now, GEICO Marine Insurance Company sued Mr. Lee Mandel seeking a declaratory judgment as to the rights and obligations of the parties under 2 yacht insurance policies. In GEICO Marine versus Lee Mandel, the United States District Court for the Eastern District of New York on March 10, 2023, dealt with the private limitation of action provision of the GEICO policy and a late demand for appraisal. Lee Mandel was the owner of a 52-foot SeaRay sedan bridge model seafaring vessel. GEICO issued Mandel 2 yacht insurance policies for 2015 to 2016 and from 2016 to 2017. Both policies required that, quote, with respect to any claim or loss to insured property, the action must begin within 1 year of the date of the loss or damage, close quote. In December of 2015, Mandel submitted a claim for damage to the starboard, that is the right side engine. GEICO approved piecemeal repairs of approximately $92,400. In July of 2016, Mandel submitted a supplemental claim for damages caused by a crack in the engine cylinder. In August of 2016, Mandel submitted a claim for damages to the port or left side engine. Afterward, the starboard engine began emitting blue-white smoke. GEICO inspected the vessel in September and November of 2016 to investigate Mandel's claims. In December of 2016, Mandel removed and replaced the starboard and port engines. In February, GEICO gave Mandel a supplemental and final payment of approximately $17,400 for damage to the starboard engine. GEICO inspected the vessel once again in November of 2017. GEICO's February 2018 report declined to pay Mandel the replacement cost of the engine because the decision to proceed with the replacement of Mr. Mandel's engines was made at his direction and not in accordance with the previous settlements issued, since replacement of both engines and auxiliary components did not represent as set forth by the policy a reasonable cost to repair, but instead constituted betterment. That is, he got brand new engines instead of a repaired engine. Later that month, GEICO paid Mandel $23,200 for damage to the port engine. Over a year later, in April of 2019, Mandel renewed his demand for the cost of replacing the starboard and port engines, approximately $213,500, and advised that he would pursue litigation if not paid. The complaint for declaratory relief asserted 3 causes of action based on the insurance policy's exclusion and the 1-year limitation for bringing legal action. And in December of 2019, GEICO moved for partial summary judgment on its 3rd cause of action regarding the policy's 1-year limitation and on Mandel's counterclaims for breach of contract and bad faith. The court held that Mandel's breach of contract counterclaim accrued in February of 2018 when GEICO advised Mandel that it declined to pay his demands. Since the breach of contract counterclaim was filed more than a year after liability accrued, it was time barred under the policy's 1-year time limitation provision. As to the claim for breach of the implied covenant of good faith and fair dealing, the court held that this claim was also time-barred with respect to the allegedly negligent or inadequate investigation and failure to promptly conclude its investigation. The court noted that a prima facie case of bad faith requires a showing of gross disregard of the insured's interests. Mandel claimed GEICO initiated this action instead of an appraisal and rejected multiple settlement offers in order to punish Mr. Mandel for attempting to get the insurance coverage he paid for. Mandel also argued that GEICO had no reasonable belief that the claims were not covered. Mandel's claim, the court concluded, for breach of the implied covenant of good faith and fair dealing failed for a panoply of reasons, including all of his claims were time-barred by the policy's one-year time limitation, and Mandel did not seek an appraisal within a reasonable time because the one-year deadline for submitting his claim had already passed. GEICO acted well within its rights by seeking a judicial determination that it had no legal obligations with respect to the subject vessel's engines because they were time-barred under the policy. Moreover, an appraisal is not an appropriate remedy because the dispute turned on whether engine replacement constituted an excludable betterment under the policies. An appraisal is limited to determining the amount of loss, not a coverage issue. Therefore, the court granted GEICO's summary judgment on Mandel's counterclaim for breach of the implied covenant of good faith and fair dealing, and found that GEICO Marine had no further obligations to Mandel under the insurance policies or at law with respect to claims involving the vessel's starboard and port engines. In my opinion, the private limitation of action provision in most first-party insurance policies have been universally upheld by the courts of the United States and the individual states. They have been enforced because they protect insurers against stale claims and protect the insurer's right to have an insured promptly fulfill the requirement of the policy to prove the loss. Mandel failed to act promptly to protect his rights, and even if his claims were well-founded, his claim against GEICO Marine had failed, and the court had no choice but to dismiss his actions and grant GEICO's motion for summary judgment. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog post and you will be advised at least 5 or 6 times a week of blog postings. You can also subscribe to the video on rumble.com or youtube.com. And if you found the videos to be useful or interesting to you, please click on the like button or the Rumble button as you do. And please tell your friends and colleagues so that they can also subscribe to the blog and to the videos. You might find it also worthwhile to subscribe for a very small fee to my locals community and or to my Substack publications. Thank you for your attention.